Welcome, everyone, as we have colleagues from across the country joining us for today's webinar. We'll kick off and get started. So my name is Claudia Fatoni. I'm the Chief Executive Officer of Women's Legal Service Victoria, and I have the privilege of being able to MC this webinar. My pronouns are she, her, and I will begin by acknowledging traditional custodians of country on whose lands we are fortunate to live, work and play, and pay my respects to elders past and present. We recognise that Aboriginal and Torres Strait Islander people continue connection and care for country since creation, and pay respects to their ongoing relationships to the lands, waters and seas across Australia. As legal services, we acknowledge the way Australia's colonial legal and justice system continues to disproportionately harm Aboriginal and Torres Strait Islander women, non-binary people and children. This land always was and always will be Aboriginal and Torres Strait Islander land, and sovereignty has never been ceded. So today we are here to talk about our Understanding Coercive Control training for lawyers. The beautiful artwork that was just on the screen is a piece called Rediscovering Me by Casey Ray, apologies, and was commissioned specifically for our project. And when you get into the doing the modules, you'll see the artwork really presented and really connects us to particularly the information and the learnings around working with First Nations people as part of the two modules. We are going to kick off with a video message from the attorney. Before we do that, just to briefly reference this project, it was a really strong collaboration informed by extensive consultation across the legal and family violence sectors. And the result of this huge consultation are two free online self-paced courses. The first is a foundational course for legal practitioners across Australian jurisdictions and practice areas. And the second is a specialised course designed for family lawyers practicing nationwide. The training really supports culturally safe, responsive legal practice with diverse clients, including First Nations people, by drawing on decades of legal practice experience in family and domestic violence. It's free, if I didn't mention that earlier, and it's also able to be lawyers can claim CPD points across all jurisdictions. So really commend this training and all the work across the project partners and everyone else that has contributed to this training. We're really pleased that the Attorney General's Department has supported this training through the provision of funding, and now we'll invite or share a short video message from the Attorney General, the Honourable Michelle Rowland.
Good afternoon. It's my pleasure to welcome you all today to the launch of the National Training Program on Understanding Coercive Control when providing legal assistance. The Albanese Government recognises coercive control as a pressing issue that requires a coordinated national approach. We know that coercive control is almost always an underpinning dynamic of a family and domestic violence situation. The coercive control training we are launching today will strengthen Australia's legal system response to family and domestic violence. The training, which is the first of its kind nationally, is available for free to all lawyers across Australia and is CPD eligible. The training has been designed for all lawyers, regardless of jurisdiction or practice area. We know that coercive control issues arise across many areas of law, including criminal law, migration, tenancy and financial matters, not just family law. It also does not belong only to certain postcodes, cultural or social economic groups. It knows no boundaries and is often silent and almost invisible. The package has been developed by Women's Legal Service Victoria, First Nations Advocates Against Family Violence, National Legal Aid and Women's Legal Services Australia. These are organisations contributing their decades of frontline experience to enable lawyers to identify and respond safely and effectively to coercive and controlling behaviour, and I thank them for this important work. The training itself is grounded in real legal practice and has been developed through consultation with practitioners and people with lived experience. The training also incorporates specific guidance developed by First Nations advocates against family violence, reflecting the unique cultural and legal contexts for Aboriginal and Torres Strait Islander clients. I understand the course was rated very highly by the lawyers who participated in the pilot testing phase, with 100% of participants agreeing that the course equipped them with the knowledge to make a positive difference to their clients. Lawyers play a critical role in the lives of their clients, often advising in moments of crisis and on life-changing decisions. You all have a role to play in identifying coercive control and ensuring that you support your client. Critically, you must ensure that you don't inadvertently perpetuate the harm caused by coercive control or play a role in enabling it. We trust this training provides the information and skills needed to ensure this. This launch is another positive step in the right direction, but we know there's more to do. The training reflects one component of the government's commitment to supporting a justice system that can identify all forms of violence and experiences and provide appropriate responses to ensure the best possible outcomes for victims. The government is committed to ongoing improvements to these systems to better support and protect victims and survivors of family, domestic and sexual violence. This includes committing nearly $5 billion to ensure women's safety, especially the prevention of family, domestic and sexual violence, remains a key priority. We're also consulting on the development of 5 new action plans that sit under 4 national frameworks relating to family and child safety. This includes consultation on the National Plan to End Violence Against Women and Children Second Action Plan. Each framework reflects that responsibility for addressing coercive control and keeping women and children safe from gender-based violence is a whole of community and cross-sector responsibility, and something that this government takes very seriously. I look forward to continuing to work with you, including through the National Plan to End Violence Against Women and Children Second Action Plan development throughout this year, to deliver ongoing improvements to the justice system and provide the best possible outcomes for victims and survivors of family and domestic violence. Thank you.
Thank you to the Attorney-General for preparing that video message for us today, and to reiterate her view and our view in implementing the project is the importance of the legal sector and the entire legal sector, all lawyers across the country, practice areas having the skills and knowledge to identify family and domestic violence and respond appropriately to a client's needs. We're going to hear from 2 of our project partners in a moment, but I wanted to share a reflection from one of our lived expertise consultants who contributed to this project. And she posted on LinkedIn recently and said, bringing together professional expertise and lived expertise creates stronger, more responsive systems and services. And I think you can all agree that's what we're all aiming to achieve. So this project was a huge collaborative effort. I'd now like to ask 2 of our project partners, Talia Rose Vanissum from First Nations Advocates Against Family Violence and Catherine Post from National Legal Aid, to share their project reflections.
Thanks very much, Claudia. Thank you everyone for being here today. It's great to see so many have joined this launch, and it's really, really exciting. National Legal Aid is very proud to be part of this consortium with Women's Legal Service Victoria, First Nations Advocates Against Family Violence and Women's Legal Services Australia. So grounded in the really significant frontline practice expertise of those project partners, as well as the lived experience of victim survivors. Together, we've built really practical, accessible national training to develop this important capability right across the profession. So this training matters because lawyers meet people experiencing coercive control every day. It might be in family law, criminal law, child protection, migration, tenancy, debt, social security or property matters, and often the legal problem in front of lawyers is only one part of a wider pattern of fear, isolation, intimidation, and control that a victim survivor might be experiencing. And we know that coercive control is not always obvious. It's usually a pattern, not a single incident. It can include financial control, monitoring threats, isolation, systems abuse, or just the slow erosion of a person's independence over time. And if we don't understand those dynamics, we can miss what's really happening, and that can lead to unsafe outcomes. So that's why this training is so important for the whole profession. Lawyers are often trusted at moments of crisis, as the attorney noted in her opening address. And the questions that we ask as lawyers, how we take instructions, what we record, the referrals that we make, and the way we advocate can all affect a client's safety. So lawyers need to be able to recognise coercive control, to be able to respond in trauma-informed ways, to understand cultural context, and to work safely with clients from diverse communities, including First Nations clients. And it's also about consistency. Lawyers across Australia do not all receive the same training in family and domestic violence, and many have had little formal education, perhaps about coercive control, and that matters. Misidentifying a victim survivor as a person using violence remains a serious risk across jurisdictions, especially for people who already face barriers to being heard. So a shared understanding helps us move away from incident-based responses and towards a better understanding of patterns, context, and safety. This work also supports the National Plan to End Violence Against Women and Children, which calls for stronger workforce capability across the legal profession and trauma-informed, culturally safe responses. And it aligns with the national principles to address coercive control and bring those principles into everyday legal practice. As Claudia said, and I'll repeat again, the training is free, online, self-paced, and available nationally with CPD points. It's CPD eligible, so it includes, as we'll go into, a foundational course plus a family law specific course, and can support continuing professional development. Its real purpose is to strengthen practice. Our hope is that understanding coercive control becomes a baseline competency for legal practice in Australia, so that lawyers can ask better questions, identify risk earlier, avoid misidentification, make safe referrals, and advocate more effectively towards a legal system that's more informed, more culturally responsible, and more accountable to victim survivors. National Legal Aid is really proud to bring a national perspective and a practical understanding of how these issues appear across the legal assistance system. Legal aid commissions work with clients in every state and territory, including in regional and remote communities, and that reach gives us both an opportunity and a responsibility to help strengthen the profession's response. Really exciting. This project shows what is possible when the legal assistance sector, with specialist expertise, First Nations expertise, and national partners all work together. And I congratulate the project partners involved and thank the Australian Government for supporting this really important initiative. We hope that every lawyer will complete the training and every legal workplace will support its staff to do so, because when lawyers understand coercive control, we are better able to see the whole picture, respond with care, and help make the legal system safer for the people who turn to it for help. So thank you, and I'll hand over to the wonderful Talia Rose from First Nations Advocates Against Family Violence. Thank you very much.
Thanks, Catherine. As Claudia and Catherine mentioned, I'm Talia Rose Van Issum. I'm a Whopper Borough woman and the Strategic Director, one of two, here at First Nations Advocates Against Family Violence. For those who haven't come across us before, this might be your first time. We're the national peak body for the family violence prevention and legal services sector, which are a bespoke area of the legal assistance sector that have a really unique model in recognizing and responding to domestic and sexual violence for Aboriginal and Torres Strait Islander people. All our members and organisations are run by our community, for our community, and are involved through the provision of legal assistance, representation, court support, healing, and right through to prevention measures and community legal education as well. So we have a wide range of us, a wide range of members that are operating at all parts of the domestic violence and legal assistance kind of ecosystems. And that's why it was so important to us that we were involved in this project. And we really wanted to recognise the importance of the mainstream partners, or like Legal Aid, of Women's Legal Services Victoria, inviting us to be a part of this project with them so that we could work together to embed that wide range of expertise across all elements of this project. And for us, reflecting on this, it's been a real shift in the way that we do business together, where we can lean on each other's strengths to make sure that all of our community is represented and feels included along the way. I think when you get to, hopefully all of you get to log in and do the training, you'll see that First Nations content through our members and through our stakeholders that we've been able to engage with has been embedded throughout the module, which has allowed us to give kind of more depth and breadth to the insights and the contextualizations of each of the elements in place, rather than it being an add-on that not many people might get to, while we advocate for kind of in-depth cultural training. If you can get to it, we also know that people that often find time for those things are already pretty socially justice minded and might already be key allies for our community. So being able to build up understandings of the different intersectional or culturally different contexts that our people may be experiencing coercive control as a baseline across both of these modules was really important for us to be able to expose people who may not have been exposed to the kind of key priorities or differences for our communities, to be exposed to that for the first time, rather than having to search for it. I think we wanted to make sure that we really targeted the way that people kind of were practicing, and that they understand how to build relationships with our community members and how that can inform their practice, so that it's not just a give and take, and the way that questions are asked often don't elicit the information that is most pertinent to what legal course that you guys want to take as lawyers. But as a community member, we need to be asked in a certain way to get the information that we need. So we spoke about and were able to explore through all of our consultations what that might look like, and how we can ask the right questions to enable clients or community members to self-determine what safety in their community looks like for them, so that lawyers can better understand how impacts of controlling behaviour impact social and emotional well-being of our people. And I think that, alongside the recognition that while everybody has a place in understanding the unique context of Aboriginal and Torres Strait Islander people's experiences, it's okay to recognise where you have gaps that can only be filled by Aboriginal community-controlled organisations. And that's why we really wanted this partnership to highlight the strengths of the family violence prevention legal services sector, where they exist and where they don't, where ACCOs that have like-minded principles and sister organisations around the countries may exist that you can reach out to if you're in a practice that doesn't have an Indigenous specialisation, to make sure that we can work together to get the best end result for those community members, and that justice and the ongoing supports that many of our community members with compounding needs are provided those strong referral pathways. So that was really kind of the why this project mattered to us, building not only that baseline competency for all, but increasing the visibility of our sector and encouraging people to reach out and to make those connections. Because if you're coming to day of and you need to reach out and make that connection, it's often too late, and it can be really hard to get that buy-in in our community to provide those wraparound supports. So we wanted to encourage people to reach out, give them the context and the school, hopefully some of the tools required to be able to build really meaningful relationships with not only their First Nations client, but the Aboriginal community-controlled organisations in their community, and hopefully improve the outcomes, not only for that client, but for the people that are working in their organisation, to understand the culturally enriched diversity and history of the place that they're living in as well. So that's my little spiels, but I also wanted to thank everyone that's been involved in this process today, and the funding that has allowed us to engage with Aboriginal and Torres Strait Islander peoples across the country to have their voices elevated through this project. Not only were we able to bring our members together in new ways to articulate shared goals in the coercive control space, but make new connections and strengthen connections within our own community with mob with lived experience of coercive control, as well as academics, some young survivors that are growing up and now championing research in this space, which you'll hear from very shortly on the panel, but also very importantly, commission a piece of art from a Gamilaroi artist which you saw quickly before, that has an amazing story behind it that allows us and upholds our way of being and storytelling into this module, so that people that are going through it can understand in that more visual way how things interconnect in our communities, and hope that helps them on their practice, but also allows us to decolonize this training a little bit. So yeah, thanks everyone.
Wonderful. Thanks so much, Catherine and Talia Rose, for your reflections on this project, really highlighting the strength of the collaboration, which does require a whole bunch of things to go well. Effective collaboration really requires high trust. It requires resourcing in order to be able to really take the time to contribute to a piece of work like this. It requires good systems and processes, and we were fortunate to have all of that in the project, and I think it has delivered an exceptional product, an exceptional learning product for lawyers across Australia. We now have a wonderful panel. We're going to spend the next little while hearing from them about their expertise and their views on this important training. So I'll do some introduction to each of our panellists. So firstly, we have Hayley Foster, who is the Director of Family Violence and Director of Access, Equity and Inclusion at the Federal Circuit and Family Court of Australia. And Hayley's charged with advising the Chief Justice and CEO on enhancing the court's response to family violence and increasing accessibility for diverse populations. Hayley's a recognised leader in family, domestic and sexual violence prevention efforts, with a career spanning frontline services, behaviour change, law practice, policy development and executive leadership. So welcome, Hayley. We have Jane Wangman, who's an Associate Professor in the Faculty of Law at the University of Technology, Sydney. Jane's research explores legal responses to family and domestic violence across legal domains, including criminal law, family law and civil protection orders. And in Jane's research, she draws on over 30 years of work as a solicitor in government policy and law reform, and now as an academic. So welcome, Jane. Our third panellist is Hannah Taylor Civitarese, who is a proud Kamilaroi woman, currently in the writing stage of her PhD on the intersecting factors of coercive control for First Nations women. Hannah's research centres the voices of First Nation women. She is a social worker and social scientist and passionate about ensuring her community's voices are included. And our fourth panellist is Caitlin Weatherby-Fell, who is the Chief Executive Officer and Principal Lawyer of the Top End Women's Legal Service, a specialist women's legal service based on Larrakia land in Darwin and covering the Top End region. Caitlin advocates for systemic and legislative changes to alleviate and eradicate domestic, family and sexual violence at both the territory and Commonwealth levels, with a particular focus on intersectional vulnerabilities, the impacts of remoteness and lived experience through a gendered lens. So welcome, Caitlin, Hannah, Jane and Hayley. It's great to have you here with us this afternoon. I'll kick off, perhaps Caitlin, with you as the first question. Why is it important for all lawyers, regardless of practice areas, to be able to identify and respond to coercive control?
Thanks, Claudia. So a foundational understanding of gendered violence is so critical for legal practitioners, given the pervasive ways in which family violence can impact victim survivors. We've heard from the Attorney General earlier that family violence intersects across multiple areas of law, not just family law or child protection matters. We're talking housing, businesses, migration, employment. So the recommendation of Women's Legal Services Australia is that training in and around family violence form part of every legal practitioner's training across the country, whether it be through law school, through practical legal training, PLT, or through continuing professional development for existing and practicing legal practitioners. This is so critical to ensuring that lawyers across the country can identify when violence is occurring, to identify a user of violence or a victim survivor of violence, or perhaps a misidentification of one of those two, and to ensure that they are equipped to respond early and appropriately to ensure that there is no more abusive process occurring thereafter.
Yeah, thank you, Caitlin. Great points. And Jane, if I could bring in, in terms of your research expertise, is there anything you'd add around the need for all family lawyers, across practice areas to understand coercive control?
So first, I think it is really important to reiterate what the Attorney General and Caitlin have just said, is like it is relevant to almost every area of law. And there has been a tendency in the past to just think about criminal law and family law. And I think one of the great innovations of this package is the foundational training module for all lawyers. I think the other thing that's important is the intensification of legal problems for people experiencing coercive control. So there was earlier research by the Law and Justice Foundation in New South Wales that found that victims of domestic and family violence were 10 times more likely to have other legal problems than someone that hadn't experienced it. So it's not just that it's relevant to every area of law, but that there might be multiple legal issues and questions being posed at the same time. I think the other thing that's important is that for many legal practitioners, they might not have studied domestic and family violence content in their university studies. And certainly coercive control might be a particularly new language for them. And I don't mean, it just means that it's not compulsory as part of a law degree. That doesn't mean that it's not happening at universities. Many universities are doing very interesting things about domestic and family violence in law. But depending on where you studied and what subjects you took, as the Queensland Women's Safety and Justice Task Force found, you could leave law school and not have encountered any of this content. And so that's why it's really important, as Caitlin said, to make sure that there's multiple levels of education, university, PLT, and a CPD program like this. I guess the other thing I would add is remembering that it's not just substantive law, it's relevant to procedure, how you interview clients, negotiations, mediation, everything that you do. And that if you really want to sort of sum it up, it's about being a competent lawyer. It's about making sure that you deliver on your professional responsibilities. So understanding coercive control is just essential if you want to do a good job.
Yeah, fantastic, Jane. That's so true. And particularly as you highlight sort of the complexity of legal issues in and around victim survivors of family and domestic violence. And the need to be able to be properly equipped to be able to support and navigate those issues. Hannah, I might bring you in here around the role of the legal profession, and what do you think that the legal profession can do in strengthening responses to coercive control across the broader system?
Great question. So just wanted to say hi to everyone. I am a proud Camilla woman. My name is Hannah Taylor Civitarese. It's added my husband's last name on there too. And I just want to acknowledge that I come from, I live on Kaurna country, but I'm here on Turrbal and Yalgoo country up in Queensland. And just want to acknowledge the amazing work that Talia Rose and the First Nations Advocates Against Family Violence, the amazing work you guys are doing, and the incredible beautiful artwork that was there before. It's so stunning to see someone from the community doing some amazing stuff. I do just love what Talia Rose said around decolonising the training and also adding the First Nations information and aspect. It's embedded within the training rather than just being an add-on, which is so key to the work that everybody is doing. I do come to everyone not as a lawyer. I do think law is amazing. And if I was smarter back in high school, I would have definitely studied law. So I come to you, like, I'll be honest, as a social worker and a social scientist, and the factors that law play into this part are so fundamental. And if we look at the fact that, coercive control, as people know, is bringing about another framework of understanding, whereas, for police, everything used to be incidents focused. And, you'd look at this incident and then there'd be another incident and then you'd look at that incident. And so a lot of what my understanding in working with lawyers has been is that incident focus. And so the amazing part and role that the legal service play is really moving away from that incident focus to that pattern of behaviour, because sometimes, for our women, I know that when we're in it and when we're a part of a domestic and family violence relationship and there's coercive control, sometimes it's really hard to see a pattern of behaviour, especially if that pattern doesn't always include an escalation of violence, physical violence. And there's still those methodologies that violence is always a part of coercive control or physical violence. Often even yesterday I was having a yarn with someone, it doesn't hit me, so therefore it's not coercive control, or it's not domestic and family violence. And so the legal part's job is to really identify those patterns and to show where that evidence needs to be pulled out to be able to present what is a pattern of behaviour with the intent to cause harm and to control somebody's life. And so within that, the role that the legal service plays is providing language, because coercive control is still quite a mystical terminology. It's not very, it's more, you know, I hear a lot of women that talk about, especially in the research I'm doing, it's a feeling, it's a sense that they feel in that relationship. And we know as experts that it's the undercurrent of someone having power, control and dominance over a person. But unless you have the language to be able to say this is actually coercive control behaviour, it's really hard, and it disempowers our community. And so the legal service has a really hopeful role to play to be able to say this is actually what coercive control looks like. This is the pattern of behaviour when someone's trying to have dominance, control and power over you. And so for our women, it's being able for them to be able to sit in the space and be educated together on what that looks like, and the fact that they do have a voice and there is self-determination, and it's not just a feeling or a sense, it's actually coercive control, and there's language and laws to it.
Yeah, that's so just such a great point, Hannah, around, you know, the pattern of behaviour and moving away from those incident-based responses. And we know there's, you know, criminal law is a state and territory jurisdiction, so there are slightly variances around coercive control legislation across the country, but that underlying understanding that it is a pattern of behaviour, and how, to your point, how you support someone who may not be recognising it is coercive control and helping them understand their experience, and then how a professional such as a lawyer can really support them to navigate what they're experiencing is such an incredibly important point. Hayley, can I bring in your lens from the family law court, which, you know, as Jane said, often people think about family and domestic violence really only pertinent to criminal and family law. What's your thoughts on the legal profession's role in strengthening responses across the system?
Thanks, Claudia, and great to be with you. I'm coming to you from Gadigal country of the Eora Nation, and pay my respects as well to elders past, present and emerging. And yeah, I honestly couldn't overstate the impact of having First Nations advocates against family violence being part of this development of these modules from the get-go. It's a really good example of a genuine intersectional approach, and anyone who does this training is going to see that firsthand. And I might even say a model for doing this work and developing these sorts of programs going forward. So incredibly proud to be part of that. I think this is incredibly exciting. A lot of my role is in working with the judiciary and improving the educational offerings to judges and registrars, court child experts and other professionals within the court system. And the single biggest thing that they constantly say after receiving all this training and learning to take a real patterned approach and looking at the sort of multiple impacts and pathways to harm of coercive control is that they are incredibly frustrated when they don't have that evidence put before them in court. So I couldn't overstate how important this training is for the legal profession. You know, we have, and we talk about this, and we've heard the Prime Minister and others talk about family violence being a national crisis requiring a whole of community solution. But we've never really conceived of lawyers being part of that integrated or part of that frontline response or that specialist response. I think we've come to realise through a lot of the research that Jane Wangman was referring to and others that that lawyers are in fact a critical part of that frontline system, and they need to be equipped with the appropriate education to be able to play that part. What Hannah was saying about the pattern of approach and looking for patterns and the impacts of coercive control, that is the centerpiece of this work, is coming to realize that, and it's the kind of thing that you can't unsee. You know, once you've been exposed to it, you can't unsee those patterns. So yeah, it's really important as lawyers. In a practical sense, you do play a role, and Jane spoke just before about not just the evidence before the court and being better at your job because you can articulate that, you can identify those aspects, but it's also about understanding presentation, understanding trauma impacts, and how people do present and how it impacts upon the quality of the evidence that's put before the courts. So those sorts of things are a really, really important part of of the package and really important to doing your job, as Jane says, doing your job well. And I think the sort of the last point I'd make is around not underestimating the role that you have to actually promote safer outcomes for children, for families, no matter what part or what jurisdiction you're practicing in. But also you could be a key player in preventing serious homicidal lethal violence, which is really, really important. I didn't mention that other interesting piece is that you're actually really well positioned as legal practitioners to pick up on systems abuse or misuse of systems. Yeah. So that's another important piece that you'll get out of the education package, is really identifying how systems can be misused by perpetrators of coercive control, and making sure that you are not inadvertently playing a role in that or being weaponized as part of that abusive pattern. So, yeah.
Yeah, thanks, Hayley. That's in terms of that thinking about that systems lens, the role of lawyers in not only doing their own individual roles as the lawyers and working with clients, but actually contributing to the system as a whole, responding much more effectively and safely and trauma-informed to coercive control. We've heard about the important role that First Nations advocates against family violence has played as part of this collaboration. It's been an incredibly important role. Hannah, can I come back to you around what culturally safe and informed practice looks like for lawyers working with First Nations people experiencing coercive control?
Yeah, I can absolutely tell you how to do all of that in 30 seconds. No, joking. So it would be coming back to working with First Nations clients and connecting with the First Nations advocacy against family violence services and people within the community. And this is, again, not an all-encompassing how to be a culturally safe worker or practice. The fundamentals come down to acknowledging colonisation and coercive control show same patterns of behaviour. When Australia was colonised, the colonisers aimed to have power and control and dominance over Aboriginal and Torres Strait Islander people of Australia. And if we see, though, that relationships with state governments and systems, First Nations people are often still in that relationship with colonial constructs, if you will. And so when we're in an intimate partner violent relationships, a lot of the behaviours that we've experienced from those systems and those colonial constructs mirror the same types of behaviours that we are being perpetrated against us within an intimate partner violent relationship. So it would be kind of bizarre then to be told, we have agency, autonomy and support when what we have experienced from the legal system or the justice system or other types of systems is coercive and controlling. So in that space, it's then understanding that within the legal concept, amazing lawyers like everybody on this space are also part of the bigger system that also coerce and control. So when somebody is sitting in front of you and having a yarn with yourself, it's the parts of the story that need to be believed, and it's believing their story. And especially around misidentification, we're doing some research in the Northern Territory around misidentification, and a lot of the stories that start when that person has been misidentified and their trajectory into the legal system is profound. And so understanding that when a person says that they have been misidentified, believing their experiences and their story as well is really important. Conducting this training is obviously fundamental in this space. There's other, around domestic and family violence and First Nations people, there's DV Alert training that also provides support for practitioners to be able to identify, respond and refer around First Nations people and domestic and family violence. And it's understanding, like I say, the law is a part of a system that coerces and controls. And when a non-Indigenous person is with an Aboriginal woman, how they are then more likely to experience coercive control from all of the systems that intersect with their lives. So being a culturally safe practice takes a lot of time to be able to, do over a period of time, but each worker has a responsibility to be able to respond in a culturally safe way and believe that person when they're in front of them, understand that they are a part of a system that also coerces and controls, understand misidentification and the implications that has on a First Nations woman, and to continue the training as well, and to sit comfortably in the uncomfortable space of going, maybe we are part of the system, and the biases that people have of First Nations people, and doing some self-reflective practice on that as well as a lawyer is fundamental to be able to ensure that you are providing a safe space for Aboriginal and Torres Strait Islander people.
Yeah. Thanks, Hannah. I mean, what really resonated there was, yes, the training is really important, and these modules are fantastic to be able to provide that education, but adding on that reflective practice to understand how your own experiences, bias throughout life might be influencing your practice is really important as well. Caitlin, can I ask you, from your perspective as a service in the Northern Territory, where a significant proportion of your clients are First Nations women, what's your view around how you create culturally safe and informed practice?
Thanks, Claudia. So just really echoing everything Hannah has just said, but addendum tack on to, connecting in with community, being a part of community is central to, and the key point for us is building trust and taking the time to build a strong relationship from which your client will feel comfortable to provide instructions and then to be able to progress their matter in the most appropriate way thereafter. It's critical, we believe, in all services, but particularly when practicing in communities where there are a high population of First Nations people, to be having colleagues who are First Nations people themselves and connecting clients in at every opportunity possible with a culturally safe person to travel with them over the life of their matter. Hannah has referred to, there are lots of other training suites for practitioners to undertake at every point in practice, and to be curious and open to navigating that training along the life of their practice to make sure that we are providing the safest space possible for our clients and for their children to try and achieve, you put inverted commas, but we will, justice in a space that has already taken so much from them. So in the Territory, we refer to our services to our First Nations clients as often travelling slowly. And that is in and around acknowledging all of the trauma that our clients present to our service with, including the ongoing and terrible impacts of colonisation, and being able to progress their matters in a way that centres their voice and their autonomy and their self-determination.
Yeah, wonderful. Thanks, Caitlin. It's really that importance of all lawyers to be able to really provide that culturally safe, trauma-informed service, so that First Nations people have a choice if they want to. They can go to an ACCO, or they can go to a non-ACCO and receive the same, hopefully the same culturally safe and trauma-informed response from whichever lawyer is sitting in front of them, helping them with their matter. Jane, can I come to you about the point around early identification and intervention, and what you've seen, how that can make a difference when responding to coercive control for victim survivors? How do we get to that early intervention, early identification and intervention, and the importance of that from your perspective, both as an academic and a practitioner?
Okay, so I feel like I'm going to answer this from an odd direction, but I wanted to kind of pick up something that Hannah said earlier, and that is remembering that sometimes lawyers are the first person that anyone has ever told, or maybe that was Hayley that said that, and that lawyers play a really important role in naming things for victim survivors. So victims, particularly around coercive control, victim survivors might often come to a lawyer and talk about some things that have been happening, but they've been unable to name it. And that's why this package is really important, to be able to, a lawyer can sit back and assist victims to not feel that to sort of unpack and like counter the being gaslit and so on. So to give that reality and to speak back and to believe. So that early identification, even though we sometimes think about law as being, I guess, a tertiary response, you go to law later on, but for many women, this is actually their first point of contact of seeking help. And so it's very much a continuum about early identification about what we do. And so whoever is that first person that is spoken to is critical in terms of identifying, believing and naming, because that means that the victim survivor will continue to seek help. Because if you get a bad response the first time you talk about something, then you might not make some decisions that can ensure your safety because it was being too difficult and harmful that first encounter. I think one of the other things, it's important, I guess, with this package when we're thinking about early identification and intervention, is lawyers act for both parties. They act for victim survivors and they act for people that use violence. And so this package is really important for early identification for both sets of people. And it also makes us sort of sit back and remember that it's not just the law. Like, the law is important here, but without being able to provide the appropriate support and referrals around housing and finances and counselling and so on, is only ever going to be part of the package. And so we're not asking lawyers to do everything, but we are asking them to have some awareness of how law fits within a holistic response. And I think that those things can really make a difference to victim survivors.
Yeah, great points, Jane. Particularly around, as you said, that linking up across the broader service system. There's such an important role that lawyers can play. Hayley, can I bring you in with a view on early intervention and identification around coercive control and what a difference that can make for victim survivors?
Yeah, it's huge, really. And actually, when you've got a whole bunch of other, complex kind of legal issues, or there might be other significant barriers for particular people impacted by family violence in accessing the justice system. So when you have a lot of those barriers, or you might be more susceptible to being misidentified in the system or having systems misused against you, it's even more important. And so being able to, as a legal practitioner, having the skills and the knowledge to be able to identify and help your clients. As Jane said, a lot of people are not going to identify or name it or put those words around it, but you're going to get really high volumes. We know prevalence in the community is substantially high, and we know that particularly when accessing legal services, the vast majority of those that you're engaging with in most of those areas of law that were listed are going to have some engagement and some experience of either experiencing or using family violence. So having those skills at an early juncture is really important. It's also important because it prevents people having to retell their traumatic stories. If you can do a really good job of getting people to articulate it, asking the right questions, documenting evidence, in the first instance, it actually reduces the trauma of people having to go through and navigate a whole range of different systems going forward. And it gives them sort of that confidence as well. And it actually influences the way other systems are going to deal with them. I think Jane makes a really good point about, many lawyers in the space, and particularly in the private field or in criminal law, etc., you're going to be engaging more so with people using family violence, using coercive control, rather than working with victim survivors. So it's really critical, because we know that the trajectory changes over time, and people harden into that position and into that offending behaviour over time. So if you can, at a very early stage, identify what some of those coercive and controlling behaviours look like amongst your clients, then you can actually play a pivotal role in interrupting or disrupting those patterns or those thinking or those behaviours. And give people the opportunity to kind of engage with specialist services, engage with, some psychosocial education, to give them an opportunity to go down a different path and to reduce that offending. Because even if you're dealing with a particular matter and a particular family, perhaps upon separation or so on, or something's gone awry, then you cannot, unless you deal with and unless you give people an opportunity to change their behaviours, you're not going to be able to prevent harm for future families and future partners and children and that sort of thing down the line. So yeah, I couldn't it is absolutely critical doing that as early as possible, that piece of work, and it's just going to make a massive difference to people's outcomes and also their experience of the system.
Yeah, thanks, Hayley. Yes, that ability to possibly prevent further harm down the track, I think, is such an important point around where you can direct both victim survivors and perpetrators of violence into support services to hopefully try and, as you say, change that trajectory. Hannah, do you have a view? I mean, you're coming from a social worker, scientist lens around early identification and intervention.
Yeah, and I just echo what both Jane and Hayley and Caitlin have been saying in this whole space. It also, like I go to before, understanding the pattern, again, we even as social workers can become quite incidence focused, because that's also where our westernized training has come from, is that incident focus kind of lens. And so it's really changing the narrative to be able to understand the whole pattern. And even as social workers, we have had to sit back and just go, well, what's the narrative in the whole situation? And even where a woman is experiencing domestic and family violence from a male perpetrator, we have worked with that woman to then understand, well, actually she's experiencing coercive control from a family member or from a mother-in-law or something like that whole big picture. And so it's really important around that intervention and identification to see the broader pattern and to see the holistic person rather than an individual in a certain situation and experience. And so it is allowing that language to be able to be used. And like I said before, it's coercive control, especially in our communities, is quite smoke and mirrors. And it's not a word that is used in our languages or word that is often used in our conversations. I've not heard anyone say, are you being coerced and controlled? That is, when I'm sitting with community or yarning up and things like that. And so a part of the incredible lawyer's job is to be able to identify and then provide language and knowledge and information to that. Like I said before, that feeling, that sense of knowing that something doesn't sit right, or knowing that a relationship isn't right, but you can't quite articulate it because the expectation or the way in which we measure potentially domestic and family violence relationships is through physical violence. So it's coming and going, well, actually that type of behaviour is still not okay. And that love bombing or that jealousing is actually not okay. This is what it can look like, and this is the information. So, and then people can stop that trajectory going forward, and they can stop that person, potentially enable and empower that person to have the tools to be able to go, this is not the relationship that I want, or this is not the relationship with community or family or systems that I want to have, and learning new types of behaviours as well, which is so fundamental. You can break cycles.
Yeah, and such a good point too around that accessibility of language, making sure we're talking in ways that people understand, because you're right, often people don't use the term coercive control, even though it is, widely used in the professions that are obviously engaging with it. We've probably got time for one last question. So I'm going to ask each panellist, what's one key message you'd like lawyers to take away from today and from this training? So the lawyers online, but they can obviously go and promote the messages to their colleagues. Maybe we'll start with Hayley. You want to kick off?
Yeah, sure. I think if I was to leave you with one key message is please play your part in making sure every single legal practitioner has access to this training. There are two packages. One is for all legal practitioners across any discipline. It's a really jam-packed, high-impact piece of work in terms of like accessing the education. So please help in getting that out. And the family law specific module as well is just incredibly practical, engaging, and really high value. Please do what you can to get it out, and reach out to anyone here, any of the agencies here, including the courts, if we can assist you in getting this out to the profession.
Wonderful. Thanks, Hayley. Jane?
It's hard to say one thing, but I returned to, there was a woman I interviewed for my research many years ago, and I remember her saying to me, the lawyers know the law, but they don't understand domestic and family violence. And I think this is the critical thing that this package adds. In order to actually know the law, you also have to understand domestic and family violence, and the package provides a really important tool to help lawyers be able to do that translation work and support work effectively.
Yeah, wonderful. It's a great point. Thanks, Jane. Caitlin, what would your words of advice or takeaway message be?
Oh, there's already been two fabulous ones. I'd probably just reiterate what we talked about earlier, in that this might be a training set that you in your everyday practice, you think, oh, this doesn't apply to me. But the takeaway of family violence crosses across all areas of practice, so many areas of law to which we may not otherwise realise. This type of training is central to ensuring, as Jane has said, that we are appropriately placed practitioners wherever we're practicing and whatever we're practicing, to be playing our part in ending domestic and family violence across our country. There are so many things that we can do as practitioners to stop cycles of DV, to negate, mitigate, end cycles of systems abuse, and to be reality checking our clients that will have meaningful impact for victim survivors and their children.
Yeah, wonderful. Thanks, Caitlin. And Hannah?
I think the training is amazing, and having seen quite a bit of it and being a part of the conversations pre-development, my piece of takeaway would be is that each person here and each lawyer that does the training and sits before a client is that you are a part of ensuring that victim survivors are not always stuck in this pattern of behaviour, that they can actually have language to their experiences. And I think that that is a truly hopeful place when we talk about ending violence against women and children and holding perpetrators accountable, is that you guys are a piece of the massive puzzle as well. And so it is a hopeful space that you can provide language to people's experiences.
Yeah, wonderful. Thanks. Thanks, Hannah. Look, I'd love to have you able to spend more time with these four incredible individuals, and we could have touched on so many more areas and issues in relation to this training. But we do need to wind it up and leave it there. You'll see on the screen, please, the QR code will take you to the training. It is free. It's fantastic. I really commend every single person on the call to go on and jump and have a look at it. Even if you're not a lawyer, I think it's really interesting to go and have a look at the training and see what lawyers are seeing around in being trained on in relation to coercive control. So please scan the QR code. The training is available on the National Legal Aid website, so you can always return to it as well. And it's really just been a really fantastic end product of 12 months of significant work by a huge number of people and organisations. So can I really firstly thank the four panellists for joining us today and sharing your expertise, to the Women's Legal Service Victoria team who did an incredible job, all my colleagues in designing and delivering the eLearn modules, in partnership particularly with First Nations Advocates Against Family Violence, who really provided that critical First Nations lens and expertise, to National Legal Aid, to Women's Legal Services Australia, in particular to the victim survivors who shared their experience and insights. I think when we talk about this very challenging topic around coercive control, we must always remember that there we're talking about people, we're talking about fellow Australians, and we mustn't forget that there are victim survivors every day experiencing family violence, and we honour them, and we also honour those who haven't survived. Thank you, everyone, for joining us today. Really, please spread the word far and wide. It is fantastic training, and we really greatly appreciate you joining us today.